Hello, everyone. Hi,
Hi,
Hannah.
Nancy.
How are you?
Good. How are you?
Hey.
Hi, Nancy. How are you?
Good. How are you?
I was just going to let everybody know we're going to wait a bit. We're a little bit early.
Yeah, we're a couple minutes. I just got off another call and I'm thinking, when do we eat dinner? How do we do this? Crazy.
You don't.
Mm,
I only wish it had an impact on my weight, however.
I know, seriously. Crowds are forming.
My daughter just gave me a glass of wine, but I think she wants to put me out for the count.
Expecting a crowd tonight?
I believe so.
Good. I think Donna's eating. She's got it down.
Hi, I'm Dawn.
Hi, Dawn.
Hi, Dawn.
Yeah.
Whatever you're eating looks good.
Ah,
Oh, we're just terrible, aren't we?
We got what you can get.
That's one of my favorites.
good for you.
Mhm. It's a good supper too.
I don't like to hear that we're not eating, though. That's not good self-care.
And it's not good self-care. I'm with you 100%. I gotta do better.
As I open my second Reese's. Don't mind the crackling of the.
No, I'm just jealous.
I did have dinner, though.
Oh, see, now I'm totally shamed. Mhm. Can't believe it's September already. Goes by so fast.
It's going to be such a busy month.
I know, it always is too.
Yeah.
Yeah, she is. Hi,
Oh, there
Michelle,
she is.
welcome.
Hi, Nancy. Thank you.
That's him
Hi.
waving at you.
Hi, Michelle.
Hello.
We're just waiting for everybody to get in.
Okay.
Well, I think the rain is going to end today and we're going to have a nice stretch of sunny weather for a while. September is always a nice weather month.
Where is everybody from, actually? Are you all from the area or Boston area or? from
Philadelphia.
Oh, fun. Yeah.
Okay.
Where are you from, Thomas?
Hi there. I live in Boston right now. Originally from Rockville, Maryland.
Okay. Welcome.
Thank you so much.
We have someone from Oregon, Portland, Oregon.
Wow, Rachel.
Mm-hmm. Oh, California, Virginia. All over the place. Oh, Israel. Cutter, was that Cutter? Faith? No, we can't hear you.
Nir is here from Israel and I owe him an email. Nir, I will get to you. I am so sorry.
Michelle, I forgot to ask you, you're gonna need to show slides?
Yes, I do.
So whose Zoom is this? Faith?
Yeah, Faith, she can turn over the slides to,
So we'll have to give her permission. But I think she, there you are. Faith, can you give Michelle co-host?
Thank you.
All set?
Yes.
Faith is here, we just can't hear her. We're 7:03, when do you want to get started? You want to give it another couple minutes or?
yeah, let's do a couple more minutes and then you can introduce her. Be great. In addition to where you're from, what type of setting are you, do you currently work in?
I do compassion, fatigue, and secondary trauma for healthcare providers.
Wow, that's
Mhm.
great.
Nurse consulting and education.
Maybe
Maybe.
nursing.
Ooh. Public health, child protective services. Well, that's a really important job.
I have a nursing professor, nursing research and informatics. Also very important.
Mhm. Customer success software for clinical surveillance. Ooh. Interesting.
Nir is a plastic surgeon and a lecturer at the School of Nursing. That's
Wow.
why I owe him an email.
Ah.
We're going to talk about some of that.
Infection control. Well, that's a timely job.
I love this organizational behavior and development with a focus on competencies and redefining safe staffing.
Mm.
Love that. Okay, Nancy, 7:05. Do you think we should get going? Oh, hey,
Yeah.
Brian Mojica just get on too.
Good.
Hello, everyone.
Hi. Yeah, so let's get started. So welcome, everybody. It's good to see you and welcome to September. The summer flew by as it always does. Well, today we have a speaker who's an expert in patent law. I want to introduce to you Michele Baillie. She's a registered patent attorney with 25 years of patent law experience. She has worked with Fortune 500 companies, mid-sized companies, startups, individual inventors in the US and abroad, including Silicon Valley and New England. Michele specializes in the procurement of patents and in the counseling of clients on infringement, validity, and freedom to operate issues. Her expertise also includes counseling of clients in US and foreign patent filing strategy and portfolio management. Michele has a BS in electrical engineering from the University of Texas at Austin and a JD from the University of San Francisco School of Law. Her distinctions include being named a top women of law by Massachusetts Lawyers Weekly in 2018 and a super lawyer by New England Super Lawyers for the last several years. And she is a super person, so I will now hand it over to Michele.
Thank you, Nancy, and thank you so much for the invitations to come and speak with you. I love patents, and I'm grateful I get this opportunity to share it with all of you. So I am going to start sharing my screen. I have a presentation here. So you can see my screen, I hope.
Yep.
Great. So these are the kind of topics that I want to cover today. First, I'm going to give you a context and an overview about the different types of intellectual property, just to let you know where patents sit in that landscape. Then I'm going to cover some patent procurement topics, give you the mechanics, so what, when, why, and how about patents, talk about some strategies, how to make patents work for your business, and also address patent marking, which is a common question that I get. Then I want to touch on some related issues that comes up with when you work with employees and contractors and with partners. This is something that comes up on a regular basis when I work with my clients. And lastly, I want to talk a bit about infringement, including what to do when you think someone's infringing your patent, or if you think you're infringing someone else's patent. And there is a few things you could do to kind of reduce your risk of infringement before launch. So first, let me give you a bit of context. So this is your intellectual property toolbox. And the toolbox includes patents, trademarks, copyrights, and I like to throw in trade secrets in this as well. So each of these things cover different aspects of intellectual property. And for your business, you should think about each of these things and which one of these are relevant and how these can work complementary in a complementary fashion to help your business. So patents, what patents are for is it protects the functionality of an invention or the ornamental design. Trademarks, on the other hand, protects your brand. Most people understand what trademarks are. Same thing with copyrights. It protects original works of authorship. That can include websites, blogs, papers, videos, even the source code for software is protected by copyright. And then the fourth tool is trade secrets, which is any intellectual property that you reasonably prevent the public or competitors from learning about. Trade secrets doesn't require you to file anything anywhere with anybody. You just have to make sure that you take steps to keep it secret. Copyrights, you have a copyright as soon as you fix your work in some way, like recording music or writing a book and you write it down, or you're painting or something. As soon as you fix it, you have a copyright. Trademarks, there is such a thing as common law trademarks. As long as you use your brand, you have a trademark, but you can also register it federally as well. And today I'm here to talk about patents. So I'm not going to be touching on trademark, copyrights, and trade secrets, but I'm going to be focusing on patents. So let me give you a really quick example of how these types of tools can work together. So say you develop an app that runs on a smartphone, and you call that iHero app. That would be your brand. And of course, it's a piece of software, so there's some software code. Well, the functionality of the app is protectable using a patent. Your iHero brand is protected as a trademark, and then your software code is protected by copyright. So in just this one product, you can have 3 different types of intellectual property with that one product. So that's how it kind of works together. So what kind of activities do patents protect? Patents protect making, using, and selling a patent invention within the US. So activities that doesn't occur in the US does not fall under US patents. For example, if you manufacture a product in Canada, that making activity is not covered by a US patent. However, once you import that product into the US, it then becomes covered by the US patent. Same thing if you sell a product online in the US, like on Amazon or eBay, that selling activity is covered under the US patent. If your invention is a service, then all the steps of the method or process that make up the service have to occur in the US for it to be covered by that US patent. So here's the mechanics, the what, when, why, and how. So there are three types of patents, utility, design, and a little known thing called a plant patent. Utility patents protect the utility of the invention. That could be the structure, function, or the use of it. Design patents protect the ornamental features, and plant patents protect sexually reproduced seeds and asexually reproduced plants. They do differ a bit on patent terms. Utility patents is 20 years from filing. The date of filing of the patent application, same thing with the plant patent. Design patents are different, it's 15 years from the date of issue of the patent. Utility patents also have maintenance fees at 3.5, 7.5, 11.5 years that you have to pay to keep the patent active. Design and plant patents, on the other hand, have no maintenance fees. Once they're issued, you're good, you're done, and they're good for the full term. Now, these are not mutually exclusive. Some inventions, you can file both a utility and a design patent if your invention has both a unique functionality and ornamental feature. So there are two types of patent applications. There is what we call a regular patent application, which meets all the formal requirements, including having at least one claim, and I will explain what a claim is in a later slide. When you file it, it is queued for examination, and they are published at 18 months after their filing. There is a thing called a provisional patent application, which a lot of my clients are interested in doing. It has fewer formal requirements. Claims are not required, for example. It's not published. It has a lower filing fee, but it is a placeholder filing only, which means it is not examined. And it expires after 1 year. And where provisional patent applications could be useful, for example, is if you want to go and have something on file because you're ready to go out to talk to customers or investors or and other people, but you're not quite ready to invest in a full patent application. Like you want to find out if if this idea's got legs first. And so you want to buy yourself some time. But at the same time, you know that if you start talking to people, somebody might try to steal it. So you want to have something at least on file. So this is where provisional patent filing could be really useful. And a lot of my clients use it a lot. It is only good for 1 year and it cannot be renewed. And within that 1 year, what you can do is then file a regular patent application and then claim priority to the provisional application. And then your regular application will have the same filing date as the provisional. So it's a really useful tool in the right situation. It is, however, not available for design patents. So if you're looking to cover an ornamental feature, you can't do it with first a provisional filing. And a provisional application can also be used to obtain a filing date so that you can predate a triggering activity, which is something I'm about to talk about as well. So quickly, what's in the patent? Well, it had 3 sections: a specification, drawing, and claims. Specification is the text that describes the features in the invention. Drawings illustrates features in the invention. And then there's a thing called claims, which is the legal definition of the patent scope. So your specification and drawings can describe everything in the kitchen sink. But what the patent actually covers is defined by the claims. So if you want to know if someone is infringing, you have to look at the claims, not just at the specifications and drawings. Very importantly, the specification drawings cannot be materially amended after it's filed. You're stuck with what you file. Only thing, and what's a material amendment? Basically anything other than, say, like a typo, grammatical error, or a missing reference number you forgot to put in the drawings, but you had it in the text. That's sort of very minor things. If you want to change anything other than that, you're going to have to file a brand new application. And this comes up a lot in clients asking me, well, how much detail should I put in it? Answer is as much detail as you can, because guess what? Once we file it, you can't add the details later. So if you find out you needed something later, you didn't put it in, you're stuck. You can't use it. And if it's not in there, you can't claim it. So your patent cannot cover anything you have not described. So how do you know if your invention is patentable? Well, there are 3 statutory requirements. One, first, it has to be subject matter that is eligible for patenting. So the statute says any new and useful process, machine, manufacture, composition, or matter. It's actually a little easier to talk about what is not patentable. And the 3 categories are natural phenomenon, laws of nature, and abstract ideas. So for example, Einstein's theory of relativity, no matter how revolutionary that was, he can't patent that. It's a law of nature and he can't do it. Abstract ideas are things like mathematical concepts and mental processes. Where mathematical concepts come up these days tend to be with artificial intelligence, for example. So the model itself is a mathematical concept. So you can't patent the actual mathematical model, but you can patent the use of the mathematical model to do something specific. The second thing you have to show is novelty. There has to be something new. And not a non-obvious variation from the prior art. That's a little harder to explain. So the patent office doesn't want to reward patents for really simple tweaks. They want to reward for some real inventing. So there has to be a big enough difference from the prior art that is not obvious to someone of quote unquote ordinary skill in the art. So what is prior art? Prior art is anything that's publicly known and relevant to the invention before the filing date of your patent application. So basically what this all is saying is the patent examiner is going to look at what you say your invention is in the claim. The examiner is going to do a search of the prior art, everything that's come before that's relevant, and the examiner is going to compare the 2. And then say, okay, is there something new? And what this new thing is, do I think it's non-obvious? So that is how a patent examiner determines whether or not you've met the statutory requirements to receive a patent. Now, one of the things you could do for you to figure out for yourself how patentable an invention might be is to do what we call a patentability search of the prior art before filing. Now, this is optional. It is not required. You're not required to do anything other than file a patent application, actually, but it's always a good idea. Notably, you do not have to have a prototype. You don't have to build it. You don't have to sell it. Marketability is not a factor. It's not a requirement. Quality is not a requirement. So junk, if you invent something that's junky, nobody wants to buy, if it meets the statutory requirement, you can actually get a patent on it. Unfortunately, that also means that I see sometimes really great inventions, but I can't patent it. But that's a few things I want to mention about that. And also the US is now in a first to file patent system. I mention it because this changed in 2012. Before, the US was in the first to invent patent system. Whoever invented it first is the one entitled to the patent. That is not the case anymore. We are now, is whoever gets the patent office first is entitled to the patent. So the reason why it changed, because the rest of the world uses a first to file system, and the US was harmonizing, we were harmonizing our patent laws to the rest of the world. So now it's really critical to try and get something on file in the patent office sooner rather than later, because we're in a first to file system.
Michelle, do you want to take questions as we go, or do you want to wait? Because the question just came up in the chat.
Okay, sure. What's the question?
If you have 2 products, one or both, which may be patented, and you combine them to produce a novel product, can you patent that?
Yes, if you can show it's novel and you can show it's non-obvious. In that situation, I think the real question is that combination a non-obvious variation? So if you have 2 parts that both are known and you combine it to do something new, that would be, so theoretically, yes, that could be patentable if you could show it's a non-obvious variation. Good question. Right, so these are the stages in the life of a US patent. I realize that the slide is very busy. I'm not going to go over each of the things that's on here, but there are 4 stages in the life. The pre-filing stage, which is everything you do to prepare to file a patent application. From the time you file it to the time that you get what's called an allowance is the prosecution stage or the examination stage. An allowance means you get a notice of allowance from the examiner. That's an examiner's way of saying, okay, you are now entitled to a patent. Once you get that, you have 3 months to pay an issue fee. Once you pay that fee, then the patent issues in roughly about 4 weeks. Once it issues, you enter the post-grant phase. And if it's a utility patent, you have 3 maintenance fees. What is notable here on this chart is that patent rights do not attach until a patent actually issues. From the time you file it to the time it issues, it's patent pending. Patent pending do not have any legal rights attached to it. You can't take your patent pending and take anyone to court or send them a letter to tell them to stop, anything like that. There are no legal rights. Does not happen until it actually issues. So that's the mechanics. And it's probably a little dry, but hopefully this will make it a little more interesting. These are the strategies about making the patents work for your business. So why would you want to get a patent? Well, there's several reasons. One, it helps to protect your investment, your research and development investment, and the time and effort you take into bringing something to market. You don't want to put in all that work and then just have somebody simply steal it. Same thing with your investors' money. They want a chance to get a return on their investment. And if somebody could simply copy it, then that just impacts their ability to do that. Patents also build value in the business. It is property. It is an asset. You can license this, you can sell it, you can assign it. You can even use as collateral for a loan. So it is an actual asset for your business. And lastly, it protects your ability to do your business. So a common thing that I hear is people say, well, I'm never going to take anybody to court. It's expensive, it's messy, I would never do that. So what would be the point? Well, patents could be useful in ways other than suing people. For example, the law says that there can only be one patent per invention. That means that if you get a patent for that invention, nobody else can get a patent for the same invention. So by simply doing that, you prevent someone else from getting a patent. And this is particularly important now because we are in a first to file system, and it's possible for 2 parties to come up with the same or very similar inventions independently. So if they get to the patent office first, they're entitled to the patent, even if you invented it first. It doesn't matter anymore. So sometimes going and getting a patent could be important. Also, when you get a patent, it creates prior art for everyone else. Anybody who files for a patent application after that have to get around your patent. They have to show that it is a non-various variation from what you have. And that could be very useful. And lastly, the patent could be the basis for some non-court actions. For example, you could use the patent with U.S. Customs to ask them to block certain infringing products from coming in. You could file a request for the International Trade Commission for the same purpose. And even online platforms like Amazon have a program where you could submit a form if you think someone's infringing on your patent and your trademark or your copyright, intellectual property, and ask Amazon to take it off. So if you don't have a patent, you can't ask them to do that. They ask for the patent numbers and so forth. So that could be a way to use it that is other than going to court and suing somebody. So when should you patent it? Well, before you need it. If you wait until you need it, it's probably too late. It does take several years for a utility patent to get it to issue. Design patents are a little faster, but you're still looking at a year, maybe a year and a half. So sooner better than later is always what I tell my clients. Now, you have to be aware of some triggering activities because you're not allowed to just kind of sit on your invention and not file for patent protection for an unlimited period of time. There are certain things that you do that will trigger a clock running. So the first thing is a public disclosure. So any communication about the invention that is not covered by confidentiality is a public disclosure. So for example, if you write a paper, post something on a website, post something on social media, do a slide deck presentation to people, that's all a public disclosure. Second thing is a public use. That tends to come up with demonstrations like at trade shows, and you just want to show somebody how your widget works. That is a public use, and that will start the clock running as well. And in the US, you also have to watch out for an offer for sale. So you go talk to someone to see they might be potentially interested in putting in an order, anything like that, that's an offer for sale. Now, with disclosures and use, I highlight the word public. If you have a confidentiality agreement in place, like an NDA, it's not a public disclosure or public use. So you can protect yourself from that being a triggering activity in that way. Offer for sales, however, that doesn't apply. Secret sales will still be a triggering activity. So a confidentiality agreement will not help you there. Now, in the US, you have a 1-year grace period from the first instance of a public disclosure or use or an offer for sale to file something in the patent office. If you don't, you forfeit your US patent rights forever. There is no way to get it back. There's no appeal. You miss it, that's it. However, it is only in the US that you get this 1 year. The rest of the world, you don't get this grace period. So for example, I think I saw that there was someone in London. UK doesn't have this grace period. So as soon as you have a public disclosure or public use, offer for sale is not relevant in the UK. Either of those, you forfeit your patent rights in the UK. That's it. This means that if you are interested in preserving your patent rights in countries other than the US, you have to actually pretend like that grace period, 1-year grace period isn't there. You have to have something on file before a public disclosure or public use. So this comes up all the time when I talk to clients. And it's one of the questions I ask in our very first meeting with a client. Have you had any public disclosures? Have you done any demonstrations? Have you talked to anybody about, buying your product or anything like that? Because I need to know, because I need to make sure I get an application on file for you within a year of that first instance.
So there's another question.
Mm-hmm.
How about filing for a grant and explaining the grant? Does that count as public? I have judged a few J&J quick-fire challenges where many judges know many specs.
Yeah, if there's no confidentiality agreement in place, then yes, that would constitute a public disclosure. And that comes up quite a bit. And one of the questions usually judges will ask is, do you have an application on file? And hopefully the answer is yes. So some strategic considerations for you. So always go for quality over quantity. Patenting can be costly. It is an investment. And there's no need for you to patent everything. You just have to patent the key things. And a good patent attorney can help you think through what makes sense for you to patent. And some of the things for you to think about, a key thing is the target. I can write a patent application to target a particular party in a space, in a market. So are we going to target your competitors? Is that who you're trying to block? Maybe we got to think about where your markets are, who your customers are, your manufacturers, maybe that's who you want to block. Developers and designers, is that who you're trying to target? And also potential partners. If you're hoping to partner someone, a good way to incentivize them is to have a patent on the technology they're interested in. So we can talk about that and see if we can get your patents to cover that. Same thing if you're hoping to sell your company. If buyers want to make sure that if they're buying your company, that you have the right intellectual property covered, and the patent can do that as part of that. Also, you want to strike a balance between narrow and broad patent scope. There is a common misconception that broad is always better, and that's actually not always true. Broad patents have a tougher time getting through the patent office, but if you can get it, you do get more infringers. It covers more. But believe it or not, you can actually invalidate a patent after it issues. And a broad patent is more vulnerable to invalidation. Where a narrow patent is easier to get through the patent office, but it doesn't cover as many infringers, but it's also less susceptible to invalidation. Usually you want to strike a balance between those two in a way that makes sense. And don't forget about the solution that you didn't adopt. It's unlikely that the solution you end up implementing is the one and only thing you thought of. Usually there's a whole set of them, and then you pick the one that you did for various reasons. Well, all those other solutions are in your inventions too, and you could patent those. In fact, some of those could be the solutions your competitors would adopt, or they would be the design arounds that they would adopt. So if you can cover those, you actually can take that option away from others, if that is what you want to do. You also have to remember to patent your improvements. What you don't want to have happen is if you get a patent on a core technology, and then your competitors start patenting the improvements, and they end up patenting all around you. And you could actually make it very difficult for you to grow without worrying about bumping into somebody else's patent. So you do want to keep filing and making sure that your portfolio is current by patenting your improvements. And to that point, review your patent strategy and portfolio periodically. Your business is not going to stay the same, it's going to change. And your patent portfolio should change with it. So if there's certain things that are stale, let it go. Don't pay the maintenance fee. If you find a hole somewhere, then you can figure out, okay, what can I file to make sure that like the things that are current are actually in the pipeline. So let's talk about patent marking. So now you've gotten patent. So what do you do with it? Well, I would highly recommend that you mark your product with a patent number. It is not required, but is recommended. And the reason is because if someone is infringing, the damages doesn't actually start accruing until that infringer has notice of the patent. And marking your product with the patent number gives constructive notice to them. Otherwise, you have to give them actual notice, you can send them a letter or somehow give them actual notice. And it's just a lot easier for you if you mark it, and that way everyone gets constructive notice. So how do you properly mark your product? So you use patent or pat followed by a list of applicable patent numbers. It has to be fixed. So don't put a removable sticker. Not concealed, easy to read. You should avoid places that are subject to wear. It should be consistent, continuous. You have to mark all of them. You can't just mark a few and say that you've done, people have noticed. Ensure your licensees and contract manufacturers are properly marking them. Have sufficient control measures to make sure they're doing it right for you. Maintain good records on how you mark in case there is legal action later. And if your product is not suitable for marking, you can mark the packaging and the labeling. Or you can use something called virtual marking, where you use the patent and you follow by a web link. Now, if you use virtual marking, make sure the website is accessible to the public. So you can't allow a login, you can't ask them for the email address in order to get to it, anything like that. If your invention is a method or process claim, so if you're a service-oriented offering, there's no such thing as physical marking because there's nothing physical for you to mark. So it doesn't count against you if you're in that situation. But you can consider virtual marking and let people know about it through your website and so forth. So you'll want to routinely review and update your patent markers to make sure that they are accurate. If a patent has expired, you really should take it off. Also, you want to make sure that what's marked actually covers the product. And if you have only a component of a product that's patented, you can actually mark the product. So for example, if your product is a printer, but there's only a component in the printer, like the ink cartridge is patented, you can actually put the marking on the printer. You don't have to put it on the cartridge. You can actually put it on the printer. That's okay. Now, making sure you do it right is important because the penalties for false marking is pretty hefty. It's $500 for each offense. Now, each offense means each unit. So if you make 1 million units and you falsely mark them, the penalty is 500 times 1 million. So it's hefty enough that incentivizes people not to be diligent about doing it correctly. Now, the entity that would be going after you for false marking would be the US government, specifically the Department of Justice. So patent pending marking. So it is optional. You're not required to mark your products with patent pending. As I stated before, there's no patent rights behind patent pending. What it does is it serves as a warning to people that there could be future patent rights that they might infringe. And hopefully that is a deterrence to people. If you want to mark with patent pending, don't put it on there until patent application is actually filed. Use common sense in terms of where and how. And if your application is no longer pending, you have to take it off. Otherwise, it'd be false marking. And also, once your patent application issues and you get a patent number, you have to change the patent pending to the patent number, which is what I talked about in the previous slides. So here's some related issues. You want to watch my time here. So these are things that come up all the time with my clients. When you're working with employees and contractors, protect your communications with written confidentiality agreements. That's just good business practice. And in addition to that, it keeps any kind of communications from becoming one of those triggering events that starts a clock running for you. Educate your staff to avoid these inadvertent public disclosures. Where this tends to happen is within sales and marketing, where salespeople want to tell people all the great things the company are doing and they might let something slip. Marketing, sometimes people post things on websites or social media without clearing it, not realizing that they're starting a clock running. So if you educate your staff about this, then they'll know, to look out for it and get clearance. Ownership issues come up all the time, unfortunately. So I'm going to tell you about what can happen, and hopefully you can avoid this for yourself. Under US patent law, absent a written assignment, each inventor owns 100% of the patent. There is no such thing as work for hire, like in patents, as there is in copyright. Just because someone works for you or you hire someone to help you with conceiving the invention does not mean you own it. You only own it if each inventor assign it to you. So it is very important to know. So have the discussion with your employees and contractors early in the process. That tends to be when everyone's friendly and want to get along and they're willing to assign ownership to you. The assignment does have to be written. And you want to include an actual assignment in the document, not just an obligation to assign. So they have to say agrees to transfer and assign, and then you add the phrase "and hereby assigns." Agrees to transfer and assign as an obligation to assign. Hereby assigns is the actual assignment. Also, it's a good idea to include an agreement for them to cooperate and to execute all documents necessary to perfect the assignment and transfer. because if you file a patent application, before I file, I'm going to be asking them to sign certain documents, attesting they're inventors and that they're signing the patent to you. And it'll be good to have their cooperation in doing that. Now, the law does require that you have to list the actual inventors on a patent. So if you have somebody who's problematic, you can't get around that problem by not listing them. Patents who don't list the actual inventors could be invalidated. So it's you don't do that. And also in these agreements, it's a good idea to document whatever inventions pre-existed in employment or contract, and to make it very clear whether they're included or excluded. Usually these lists are used to be clear about what is excluded. It's a really good way to do it. So that's a good practice for you to get into.
So a question by him, if you hire a design company to build a prototype, file an NDA, do they have rights in owning the invention?
Yes, an NDA does not address ownership. So in addition to the NDA, you should have, it could be part of the contract that you have with them that defines the scope of work. You should have in there very clearly that you own the intellectual property, and that they have an obligation to sign and assign, which you should do. Working with partners, some similar issues come up in terms of communications. Make sure you have a written confidentiality agreement. And some issues you should think about that you should address in the partnership agreement is work out who owns the IP. Are you going to own it jointly, or is it all going to be assigned to one party? Who's responsible for the patent filings? And after it's filed, who's going to direct the prosecution of the patent applications? Who do I call to ask when I get an office action after your application is filed? And who do I get direction from? Who's responsible for the patent enforcement if there is an infringer? And who's financially responsible for each stage? You should also put limits to the rights to assign or license the IP. The last thing you want is to find yourself forced to work with a third party because your partner assigned the IP to somebody. So you want to put a limit on that. Also, talk about what happens to the IP. One of the partners dissolves or goes bankrupt. You can have, for example, have a clause in there that if a partner dissolves or goes bankrupt, then their IP will be assigned to you or something like that. But you gotta talk about that and work it out. Also, what happens if the partnership dissolves? What happens to the IP if there's no more partnership? And again, document inventions that pre-exist the partnership and make it clear whether they are included as part of the partnership or excluded. So patent infringement. Here's the key patent infringement fact. That patentability and patent infringement are two separate legal questions. It is actually possible for you to have a patent on your invention and have your invention infringe another's patent. Their patents are not mutually exclusive in that way. So what happens if you think someone is infringing your patent? Well, to infringe, they have to be practicing each and every element in at least one independent claim in your patent. So how do you figure out an infringing? Well, you call your patent attorney. Your patent attorney would do an element by element infringement analysis and figure out whether that first bullet is true or not. Excuse me. Now, infringement cannot be determined hypothetically. Just be aware of that. Every so often, I'll get a client that asks me once they get a patent, and they'll ask me, so anybody who does X would infringe my patent. Is that correct? Well, my answer would be yes, if they're practicing each and every element in at least one independent claim in your patent. The only way I can know if they are is if there's an actual product or service that I can actually compare with your patent claims. So what do you do if you're accused of infringing someone else's patent, or you become aware of a patent that you're concerned you might be infringing? There's lots of different ways people become aware of when someone else's patent. Somebody tells them about it. they do a search for themselves and they find it, or if you do that patentability search we talked about, and we find something. Well, if you get a cease and desist letter, don't panic. I know you're going to panic anyway, but try not to panic. There is help out there. So call your patent attorney for help. The first thing that we have to figure out is whether or not you're in fact infringing. So we'll do that element by element infringement analysis to answer that question. And once we know the answer to that question, we can talk about the best way to respond to that letter, if there is the letter. So there are two main defenses to infringement. One, obviously, if you're not infringing, the defensive approach. If there is a cease and desist letter, we can write a non-infringement reply letter. And you should really think about having your patent attorney write a non-infringement opinion. Now, that's not something you would send to the other side, but it's something that is good for you to have in your records in case you do end up in court. That could help you. And I'll explain that in a little bit, what I mean by that. The other defense is to invalidate the patent. That is not a trivial thing to do. There is a whole set of processes involved in that, which is outside the scope of this talk. But if you can find a weakness in the patent and invalidate it, you don't infringe because there's no patent to infringe. More commonly, what my clients do when it looks like there is a significant risk of infringement is we figure out if there is a design around. You could do it to limit the infringement. If you implement a design around, then there's fewer units of your product that was infringing. So that's one of the things that an option you can consider. You have to consider both the legal and the business facts. What you do has a lot to do with who the patentee is and what the patentee really wants. The letter is going to threaten litigation, but that may not be what they really want. Maybe what they want is for you to pay a licensing fee or some kind of fee to make them go away. So these are the things you need to talk about that your patent attorney can help you figure out and take you through the process. Whatever you do, don't do nothing. That's the worst thing you could do. Because once you have notice of the patent that you potentially infringe, it does trigger a duty of due care. You have to investigate it. You have to look into it. If you do nothing and you do end up in court, you could be found to willfully infringe. And the statute says that the other side could be entitled to treble damages if you're found to be willfully infringe. Now, this is where that written non-infringement opinion comes in. If your patent attorney tells you, I don't think, in my professional opinion, I don't think you're infringing this patent, and you rely on it, then you could say, well, I didn't willfully infringe because I relied on this opinion from my patent attorney, and that could save you from the willful infringement. So something you could do to reduce your risk of infringement is to do what's called a clearance or freedom to operate search, typically done before the launch, but you can actually do it after. What the search does is identifies patents that pose infringement risks. So that gives you an opportunity to adjust if something problematic comes up. Just knowing the market is not good enough because a small number of patent inventions actually make it to the market. So you're going to miss a lot of patents that are out there if you only look at the market. There are also non-practicing entities such as universities. Universities actually own quite a bit of IP, but they don't commercialize it. So they're non-practicing entities, and universities are increasingly willing to enforce their patents and actually go after people. So the only way to really know what's out there is to do a clearance or freedom to operate search. It is costly. It's not uncommon for it to cost anywhere from $25,000 to $50,000. So there has to be some cost benefit analysis you have to go through to decide if you want to do it. If you do find something of a concern, just know it does constitute actual notice and it triggers that duty of due care. Good time to consider design arounds. If you're before the launch, it's probably the best time for you to think about doing that. If sometimes design arounds is not possible or is just not viable for you to do, you can try negotiating a license with the patentee. There are some downsides to it. The biggest one being that you're alerting the patentee to the fact that you're there. But you have to weigh that with your risk of infringement. Sometimes you can even purchase the patent. If you own it, you can't infringe your own patent. So you could buy it from them if they're willing to sell it to you. Worst case, if it's a really high risk, then you may not be able to launch. But at least you know before you launch rather than after. And that's the whole point of this. And that's the end of my presentation. So if there are any other questions, anything you want clarifying, I'd be happy to answer them.
There's one from Susan. Please define design around. How substantial does the difference need to be?
Yeah, so a design around is where, if you infringe, that means you're doing each and every element of the claim. So to stop infringing, what you have to do is to not be practicing just one of those elements. So if a claim has 5 elements, and right now you're practicing all 5, is there one of those elements you can change so that you're only doing 4? If you can, then you're no longer infringing because you're not practicing each and every element. So is there something in there? Is there some element that you can change? If you can, then that's a design around. That's what I mean by a design around. Then you avoid the patent. And in terms of, I believe, I'm sorry, I think there was another part of that question, how substantial has to be. That's a really good question. And that's a hard one. Unfortunately, that's one of those hard questions to answer in the abstract. Because not only do you have to not practice an element, you can't be an equivalent of that element. So it will really, whether or not it's an equivalent really depends on what it is that we're comparing.
So how can you, when your patent runs out, you're not allowed to patent it again? Does
That's
it
correct.
run out? Is that
Yes.
correct?
Right.
And how often did you go, with all of your experience in doing this, how often do you go with a patent and find out that somebody already invented that same thing?
It's actually rare that we find someone that invents the exact same thing. It's usually something that's similar. So it becomes a question of whether it's non-obvious variation. One of the things that's very common is with the non-obvious part is where the examiner can't find anything that's exactly the same. But it finds one patent that has some of it and another patent has some of it. And then our examiner argues, well, if you plug them together, you get your invention and it's obvious to plug them together, these things together. Then you have to argue why it's not obvious to do that. But you add something that neither of them has. And then to get around that rejection. So that's where that's usually the context that comes in.
Other questions? Anyone? Did anyone filed a patent or had problems with a patent? Denise, you're shaking your head.
Nancy, I have another question,
Okay.
if I may. If you file a provisional patent and within that year you make design iterations or changes, what do you do with that information?
That's a really good question because that happens all the time. So what I would recommend to my clients is you go ahead and file the regular application and include what was still relevant from the provisional and the new stuff that you came up with in the meantime. And the way that would end up working is the stuff that was described in the provisional will end up with have that provisional filing date and the new stuff would not. So the new stuff will have the regular application filing date. So that's how that would work. Great.
And then one other question. When you file a provisional, it's not public facing, correct? Meaning no one can see that you filed the provisional, but does a patent pending, can someone see that there is a patent pending? If I were to do a search.
Mm-hmm. Yeah, provisionals are confidential at the patent office. No one knows about it unless you tell them about it.
Right.
But you can, but it is patent pending. So you can put patent pending on your product or your literature for your service. But you're not required to give them the serial number or anything like that. Even if they have it, they can't look at it because it is not available for viewing in the on the patent system, the database, the online database.
Thank you.
How about if we're proposing a product that has to go through FDA because it requires approval, which does often take a long time? Is there anything special about that? Do we need to disclose that as part of the patent, or does one thing have nothing to do with the other?
But it's not my area, but my understanding is that one does not have to do with the other. So you could actually have a patent on something that's still waiting for FDA approval.
And so the length of time that may take, so would a provisional work for that? Because it might take a longer period of time than a provisional would allow?
Well, my understanding of the FDA approval is it's rarely less than a year. So a provisional will buy you an extra year, and that could be a good way to go if you want to delay it a bit and yet get to the patent office earlier. The reason is because your provisional filing date is not calculated as part of your patent term. So if you wait that full year to file your regular application, the patent term is calculated from the filing date of the regular application, not the provisional. So you could get your full 20 years, even though you file a provisional. So you're not giving up a year of your patent term because you file a provisional first.
Thank you.
Kimberly wants to know if you can patent a chemical composition.
Yes, you can. Absolutely.
Anybody else?
Any questions?
Anything else? No? All right. Thank you, Michelle. That was really, really interesting.
Sure. If any of you have a question later, here's my email address, my phone number. If you want to have a Zoom call, I'm going to give SONSIEL members 30 minutes of my time. If you think that'll be helpful to you, there's a link to my calendar and you're welcome to put something on the calendar, and I'll be happy to answer any questions you have.
Thank you.
Thank you so much.
You're welcome. So I'm going to stop sharing. There.
Okay.
right.
Appreciate you taking the time, Michelle. And if anybody has questions, please, I'm sure she'll be happy to answer. But I think we've gotten to the part now, the 8 o'clock, where we let you guys share whatever it is that you want to talk about.
Okay. So I will sign off, and thank you so much again for having me. I can talk about this all day, but obviously I don't want to, you don't want me to talk about it all day. So I will leave you to your meeting, and thanks again.
Okay, thanks. Have a good
Bye-bye.
night. Okay, so anybody have anything that they want to share? A lot going on. This is your time.
I'd like to share something.
Okay.
This is Mary Ann Schultz, and I am working on, I don't know if I shared this last time, I'm sorry, but I'm one of the fortunate Nursing Now winners who, there were 3 people selected to put forward the paper, to the world. I'm writing about all of you, and indirectly, the projects summarized that are interest to SONSIEL. And the working title is, hold on. The working title is Telehealth and Remote Patient Technologies, State of the Science paper. So something for everybody, you might say. And I feel very fortunate that I've received this from the Nursing Now and Burdett Trust. That's all. But indirectly, I'm writing for us, you, and wearables and all that stuff. Thank you.
Thank you, Marianne. Who else?
Oh, hi, it's Wonga here. I am actually sitting on my bed now because it's 1 a.m. in London. So I won't have my camera on. I just wanted to share that I was in the ICN Advanced Practice APN Network Conference last week, and it was incredible to see SONSIEL being highlighted, including our book and the work that is being done in leadership and innovation and entrepreneurship. So congratulations, everyone, and well done.
Thank you. Anybody get impacted by the storms that we've had? How do you deal with that? Any other thoughts on what's going on out there? I know you're all from different places around the country.
The next nurse hackathon will be the weekend of November 5th through the 7th. So put that on your calendars and hold that date. We're going to be doing a lot about how to recruit, retain, what the future of nursing looks like, what we can do. So it would be wonderful to have you all there.
I can share that I just picked up this, well, I just got sent the Future of Nursing 2020 to 2030. I haven't had an opportunity to dive in it yet, but it looks, it's pretty thick. So I'll be reviewing this, and maybe I can report a little bit back over the next year.
That'd be great.
You guys get a copy of this yet? You see?
Who's it by?
Yeah.
Kim.
It's the Future of Nursing, the Consensus Study Report, charting a path to achieve health equity. And this was done by the National Academy of Medicine.
Wow, that's great.
Wow.
That's my share. I have a lot to share, but I'll wait.
I noticed on LinkedIn, there seems to be a lot of common conversations happening. I always think it's interesting when like one person starts off something and then you find other people are talking about similar things who you maybe weren't previously connected to, and suddenly they pop up on your feed. And I just feel like there's a sort of groundswell right now. And you mentioned the Future of Nursing report. It's so timely because I think there's so many conversations going on right now about how do we create a sustainable nursing workforce? How do we really help not just those who are transitioning into the workforce, but those who have been in the workforce? How do we keep them engaged and keep people from burning out? And there's just a lot of conversation. I think we're at a really pivotal time. It just, to bring all these ideas together and really help, pivot things in the right direction.
Couldn't agree more, Denise. Anybody in the part of the country where the Delta variant is going wild? Any of you? No?
I'm not going to say it's wild in Delaware because nothing's wild in Delaware. We're too small for wild.
Yeah, I'm in Houston, and I hear it's pretty nasty out there.
Well, the problem is the numbers are rising, and trying to keep it, as I put in the chat, we're trying to use predictive analytics to try to stay ahead of it and try to figure out, where our ICU needs are. And again, being a small state, we kind of have a smaller population, but so I think that we're maybe, I know we're in better shape than some states, but I feel like we're kind of on this cusp now where we have a certain number of people who are not going to get vaccinated, and that's what they're doing, and just trying to figure out. So with that, what is the risk, and how do we deal with that?
I'm in Houston also, and I've been taking care of COVID since for a little bit more than a month now. Both vaccinated and unvaccinated.
Yeah.
Did you say kids, Kimberly?
No, I
Just
said
COVID
COVID
patients. Yeah.
Oh yeah, only adults. Yeah, no peds over here.
Robert, what were you saying about what's going on in Houston?
Oh, I'm in Houston. I'm currently looking for a job, but still have a lot of contacts. And I hear it's pretty bad out there. And I'm talking to a lot of people in other areas. So staffing and scheduling is my specialty, my background. And this whole issues with traveling nurses and just the insane rates that they're getting. It's almost turning into an arms race, and I'm afraid it's really going to end up hurting some of the less affluent systems. And there's, I think, some potential bad things for additional impacts on disparities in healthcare there. The whole traveling thing is the contracts just keep getting for more and more and more money, and they don't actually do anything to even begin to address all the underlying issues. So my big concern is that nursing is not doing enough to really look at these issues, and that we really need to be planning for the worst, which it looks like COVID is probably going to be endemic now that we have animal reservoirs, much like the swine flu and the avian flu. So we need to be planning for that, and we need to hope for the best, and that they can come out with effective vaccines and treatments. But I think everybody is, from what I'm seeing online on LinkedIn and Twitter and all the people I'm talking to, everybody's hair is on fire, and they just can't really figure out what to do about it, because the long-term employees, they see these travelers coming in making just ridiculous amounts of money, and they go to their leadership and say, hey, we've been long-term loyal employees, can we get a bump? And I'm hearing a lot of people saying that they can't even get that consideration.
I feel like we think about nursing resources in such limited ways, Robert. I agree with your point. And, about a year ago, I think about some of the organizations who did a reduction in force because they lost so much money at the peak of COVID. And so on one hand, we have a reduction in force of nursing staff when in other places, we don't have nearly enough staff to make ends meet. And like you said, we're paying huge amounts of money. And so we have to start thinking about, I think, our nursing pool. Maybe that's what the pandemic has sort of bubbled to the surface of thinking about nurses as not, an individual who works for an organization, but more broadly across the United States of how do we mobilize a workforce more rapidly and more efficiently than we've maybe done in the past.
Yeah, I agree, and I think we shot ourselves in the foot with the push for BSN staffing in so many facilities. If you look at the state of the education pipeline, that BSN pipeline just simply cannot fill the hole that we've dug for ourselves. And the bottom line is we need more caregivers at the bedside. We need eyes and hands on patients. And I really think that the only way that we're going to get out of this, because it's not going to be the BSNs. We don't have the instructors. And we're not going to get the instructors because the wages for those instructors are just so atrocious. You're not going to have these expert clinicians that would most likely make excellent instructors. They're not going to take the massive pay cut it would take to go and take one of those positions. So I think eventually, hopefully, maybe there'll be a conversation. We need to really take a look at and reevaluate the value of ADNs and LPNs, and maybe look at some more creative, or maybe going back to the future for some of the care delivery models, because we've got a lot of these capacity issues are just because they don't have bodies to put at the bedside. And if we end up having additional waves, we've got to figure out how to open up those beds. So it's a mess. It's quite the mess.
And at the same time, many hospitals have gotten rid of their clin spec roles. I've seen in my consulting, many hospitals get rid of that role, and yet that role to me was such a conduit of knowledge, especially for our new nurses as they struggle to practice. And who is there to help with the acquisition of information and the integration of that information? And I did this podcast, about a month ago about the impact of cognitive load on our new nurses and how they're struggling. And I think it was really compounded by this article I found where 72% of nurses surveyed in this research article admitted to neglecting to do a critical patient task before they left, before the end of their shift. And so all of those things that Robert just spoke about, I think we're seeing the implication in patient care of people walking out the door and being just so overwhelmed because of staffing issues, because of trying to integrate all the new information that's coming at them and function, not just efficiently, but function well and really be able to perform their tasks that they need to.
That's interesting
Yeah,
that you said that, Denise, because I'm also on the regional board of National Informatics Association. And one of the things we were talking about in our meeting is that the bedside nurses are asking for everything they do to be on a task list because number one, because especially when they're new grads, they're so afraid they're going to miss something. But because they are so overwhelmed, they want to have every single thing mapped out, and they're not using critical thinking skills because they are so overwhelmed and have to work so quickly. And so I think what you're saying is it really it's impacting even the way that the systems are designed in the informatics portion of what those nurses see and what they have to check off.
Yeah, and we haven't even talked about the demographics, the average age being 51, and just the incredible amount of human capital and knowledge that we are on the cusp of losing. So once these experienced nurses decide to leave the bedside, who's going to orient, who's going to mentor, who's going to help train and educate these new nurses? Just the exodus of knowledge is one of the things that just really disturbs me about this whole situation.
And I think it's compounded by the fact that we're using learning modalities that maybe don't match our demographics, to your point. Our younger folks, our younger nurses, they don't learn in the same way that we've been developing learning modalities all this time. They can't sit through an hour LMS and absorb in the same way that we could, or I'm saying age-wise, we could, assuming that we're all the same age, but it's different. Times have changed, and I think that we have to alter our learning approaches to accommodate a different generation, a different way of learning. There's some really interesting work around cognitive learning maps, fuzzy logic maps, and these learning maps that show in a picture way how to associate different things and bring pieces together, being more impactful than words on a screen and a PowerPoint. Not to diminish, that's the modality that we've all used for so long, but it's losing the impact, and maybe that's why we're seeing it come out in our error rates and forgetfulness and needing additional tools to help our nurses know what to do every day.
Yeah, those are all excellent points, Denise. But then it brings us back around again to the whole education question. Who's going to revamp the curriculum? Who's going to teach it? We're in quite the pickle here.
I think the level of moral injury that's going on with nurses who just can't perform at the level that they're expected to. As a nurse, I remember walking away from the bedside and feeling like I could get a good night's sleep because I did everything that I could. And now they're walking away from the bedside, not only feeling like they can't do everything that they can, but that maybe they're doing some harm. And in that a local hospital here, the nurses walked out. There was 4 ICU patients per nurse, and their patients were dying without them even being in the room. So the nurses walked out for their safety. They brought travelers in. The nurses were due to come back on Tuesday, and they locked the nurses out until Sunday without pay. like kind of waving their finger and saying like, we'll show you not to walk out. So I really do agree with this idea that we need to come together as a profession and really start to own who we are and what we do, that we're not some kind of commodity that you can just like, you know, not listen to us and send us out and then wag your finger and say, how dare you, you know, you poked the bear, so now we're going to make you pay. You know, there's so many of us and we're so respected in what we do. We're the most trusted profession, and we somehow continue to allow ourselves to be treated like we're some kind of commodity that can be bought and sold. And, you know, I think these younger nurses are really seeing it for what it is and wondering like, how sustainable is this?
I want to comment on that. This is Kimberly, and from the Bay Area, and I just want to know, in terms of reimbursement, I work in public health. I've been in public health for the last close to 30 years, but are nurses still lumped in with the room rate in terms of reimbursements? How is that calculated? Because I know even with doing home visits in the community as a public health nurse, we bill per encounter. So, and you know, you mentioned, you know, the commodification of nursing and the respect level. And I just wonder if that might be a reason. And I haven't been in a hospital in over 25 years.
Yeah. Yeah, the comment from Faith is that the nurses are still part of room and board, and I do think that that's an impacting factor on all of this, because we're not seen as revenue producers in the hospital. We're a cost item, and it's a very different way of thinking.
There's an awesome group.
I'm sorry, go ahead.
There's an awesome group called nursestransforminghealthcare.org that's really doing some grassroots work about getting the word out about how to transform healthcare into back to the theories that nurses learned based on, you know, the nurse theorists and these ideas of, you know, holism and, you know, taking care of not just the money machine, but really taking care of people and in that case, taking care of ourselves. So it's interesting if anybody wants to take a look at that.
Well, I want to comment on that. I have a master's in clinical nurse education, but of course, like you said, it's just really difficult to, you know, with family and stuff to do that, because I did accommodate some of the nursing students who were on their community health rotations. I did that for quite a long time. And then a new administration came in. I did it for free. You know, I didn't want any extra money, anything like that. So I did that for a long time. A new administration came in, so they changed that and kind of ran all the nurses away. And so that at least for the community health rotation, they had me. But it's interesting because we just need to know, without making it about money, just how we value what we, you know, what value we bring and how to quantify that. And yeah, so that was my comment. Just to
or maybe it is okay to make it about money.
Right.
I've had conversations with the CFO CFOs who've told me that literally they see no link between the number of staff and patient outcomes. CFOs who've said things like, well, I don't care if my nurses leave, I'll go find nurses to replace them. And there's a dollar value associated with that. And I think we've got to be able to at least go toe to toe and have those conversations. The average hospital spends $3.6 million to $7 million annually replacing its nursing staff.
Yep.
And that is in terms of recruiting, retention, education, onboarding, you name it. And so there is a dollar value associated with nurses walking out the door. And
Right.
It's about educating not just us in the nursing community, but our peers across the aisle in terms of financial executives, legal executives, you know, the whole range of executives.
If they're even doing retention, they're not really even doing retention. 15.9% of hospitals are having nursing turnover at this point. And at that rate, it's like $40,000 per nurse in all of that lost revenue. You know, if we could really focus on some kind of retention and help decrease these moral injuries of, you know what, you're disposable, you're replaceable. You know, when you have tenured nurses that really aren't replaceable, you know, they run the show. We know who we are. We just, you know, continue to cut off our own arms to save everybody else. And then, you know, the nurse suicide rate right now is ridiculous. And if you ask, and there's nurses who are thinking, like, because we have this compassion fatigue. You know, we are burnt to the point that we don't even know. I have had nurses tell me, I have nowhere safe to breathe. I can't go to work and breathe, and I can't come home and breathe because I have to be strong for my family. I can't break down. And are they going to come home from school again and everyone going to be locked down again? Like, where do I go? You know, it really is like, we're using these meat suits to go ahead and perform these tasks, but there's souls attached to them. And these souls are crushed. And it's just so sad to watch us be run through the ringer over and over again and say, I'll just find somebody new to do this. You know, outcomes are going to change. You know, we're going to lose money and revenue, and the money machine doesn't like that. But you know what? They'll just find somebody new anyway.
Yeah, Dawn, good points. And on the moral injury and burnout, you know, a lot of that is actually a function of the staffing and scheduling environment that we're in now.
Leadership.
It's a leadership problem.
Yep.
And like I said, my specialty is nurse staffing and scheduling for the past 22 years. And I'm actually working on setting up a blog to publish some information because I discovered some very interesting things about staffing. There's actually some very simple formulas that can be used where managers can calculate how much non-productive time they can grant each month based on fluctuations in their FTE status. And I haven't found anybody talking about this anywhere in the literature, anywhere else online, where, you know, as a manager, most of them, what's happening is, you know, they're approving time off before they go and schedule their patient care shifts. So they're frequently overspending on those time off requests, and then they take what's left over and put it at the bedside. That's how you end up with schedules posted that have open shifts or unfilled shifts. It should never happen that way. It should be the other way. You should put your patient care shifts on first. And we should be fighting for people to have, you know, vacation and education and go to conferences and stuff. We need a care-centric staffing framework, which is, you know, kind of what I'm shooting for. So I'm hoping to publish some stuff, you know, online in the next month or so. Over the past several months, I've actually approached a lot of leaders in nursing. I've spoken to a ridiculous amount of DNPs and PhDs and thought leaders and innovators and executives. And when I explain the problem to them, part of the problem is once a manager sits down and plugs in this very simple formula in Excel, it's going to show them just how short on resources they are. And out of all of these executives and you know, leaders' mouths, the very first thing that comes out, well, that's going to cost us too much money. And it's very sad and discouraging. So I've taken the stance of, well, maybe we need a grassroots effort. I'm hoping to educate nurses at the bedside. Do you want to know why you're working short-staffed? This is why. Go talk to your manager about this. Take this to your nurse manager and let them take this to leadership and have the nurse manager explain to them, well, look, I've got this formula now. For these formulas, I can tell you exactly why I've got this overtime, exactly why I've got these unfilled shifts. You guys are not giving me enough resources to cover my non-productive time.
I think Faith also pointed out in the chat that at the Nurse Hack for Health that one of the topics is about how to keep nurses at the bedside. That's correct, DM, right?
Well, I think the difference between the nurse manager going to the staff and saying, hey, you know, we need you to help. How about the nurse manager going to the staff and say, what's going on with you guys? And give me some feedback as to, you know, what's working, what's not working. Do you have any ideas? Like, start using nurses as resources for what could work. You know, we don't have to, I think that I'm a little leery of like the numbers, and I know that's the way it works. I haven't ever done any kind of managerial, but I just know that there's a lot of nurses that are coming and going from their shifts and they're not talking to anyone about how they are or what they're doing or what they think. You know, we need to use nurses as part of the cog into making things different instead of just saying, you're the ones who are going to do the work. How about you help us try and figure out how to make this a better system, because you're the ones who keep showing up.
So
That's a good point. I think
go ahead.
I've been at some hospitals where there isn't a lot of communication, but I also have been at a hospital where the manager did get a lot of feedback, but then when she went to go advocate for the staff, that's where all the pushback came from.
Sure.
And so it's almost like you needed even the managers to have their cohort and come as a collective voice instead
But
of
the
everyone.
staff, but the staff will leave the manager. They're not leaving the job. So if they have a manager who's showing up for them, they're more likely to stay on that job with a manager who listens and goes to the higher ups and gets pushback than someone who doesn't even come to them and ask anything and goes to the higher up and they get nothing. So, you know, if you honestly, the turnover rate has so much more to do with people leaving the managers, not leaving the position.
That's true, because where they did have that relationship with the manager, you had nurses there for like 30, 40 years.
Yep.
Whereas in the hospital where they don't have that, they're leaving before their 12 months.
Yeah. Well, I'm going to have to wrap us up because we're getting close to 8:30, and I think this has been a great discussion. You've come up with some ideas about, you know, how to address this, but, you know, it would be great to have future meetings talk about some real strategies. And how we can, you know, bring these ideas together and do some implementation and execution of some of these plans, because, you know, you're all correct. This is a real big problem. And don't forget, we will be talking about it at the Hacks of Health as well. Yeah. So with that, are there any other announcements that we need to make tonight?
No, but I thank you for sharing all your all the ideas and stuff. I'm just really processing what everybody's saying, but yeah, I really think that you have so much to offer, and seriously, Johnson & Johnson, SONSIEL wants to hear, Microsoft wants to hear. They're very committed to what nurses have to say to keep people at the bedside and sustain the workforce. And so even if you can just come in for a day or whatever, but as Nancy said, you know, perhaps this at the meetups, we should begin to really have very deliberate conversations and solutions and strategies.
Well,
we're a force to be reckoned with. I mean, and we forgot.
4 million of us.
How many badass nurses do we know? Like, I don't go to work to take care of patients. I go to work with my friends, and my friends rock. Like, we are strong, and, you know, we do it all. And if we can just take that energy and start banding us together, small factions, and then get together out there and just be like, you know what, we're sick of being crapped on. Like, the revolution's happening everywhere. Like, let's just don't get me started.
We've got 20 badass people here, and at the next meetup, I'm hoping we'll have 20 more. So we will have to continue this discussion, but right now, I think we should say goodnight. And I hope you all have a good evening. And thank you so much for being here. It's always delightful to see you all.
Good night.
Good
Thank you.
Good night, everybody. Take care.
Night.
Good night.
Bye, good night.